with the fluffy stuff. So this next part of the program, we're going to be talking about the Michigan Right to Farm Act and farm market GAMPs. And we'll be talking about how they relate to or are preempted by, or how local zoning is preempted by the Right to Farm Act. If at any time you get confused, you think, oh, this is kind of gray and I don't really get it, you're completely normal. The reaction is normal. It's okay. So with me tonight, Ryan Coffey Hogue is on the Zoom. He's going to be helping with Q&A, so he's just kind of listening in the background. Ryan is the chairman of the Farm Market GAMPs Committee, so he has really great background and insights onto, you know, why the rules are the way they are. They were revised in 2021, so we'll be talking about some of those changes to the Farm Market GAMPs. Brad Newman, a colleague of ours, and Kurt Schindler, many of you probably know him, were also helpful in creating this program. So to put it bluntly, or most simplistically, when we're talking about the Right to Farm Act, we're talking about that general, the growing, the production, the creation of agriculture, right? The blueberries, the cranberries, the corn, the apples, peaches, whatever that is. And then the farm market GAMP is the blueberries that went into the apple, that went into the blueberry pie, and somebody is selling that, right, to the public. It could be on their property, it could be on an affiliate property, or likewise, cranberry, they're trying to sell these cranberry wines. And we know a whole lot needs to happen before the blueberry gets to market in the pie. So that's the middle part, the Agricultural Processing Act. So we will be hitting on that briefly as well. So in the most simplistic terms, that's where we're headed tonight. Okay? Yeah? Question?
You're talking about the wine there. I thought Right to Farm did not have anything to do with alcohol-related stuff.
Well, we'll talk about that in just terms of a farm product example. So a little bit of background on the Right to Farm. It's helpful to understand how we got to where we are at this point. So in the 70s, there was a lot of growth in Michigan and started to see these rural, you know, suburban clashes. And farmers were experiencing these private lawsuits regarding odors or, you know, soil erosion, whatever, what have you. We refer to these as nuisance lawsuits. And so in 1981, the Right to Farm Act was adopted, which protected existing farms from these nuisance suits. And then after that, in response to that, zoning laws started to become more restrictive around the state as a kind of a back-end way to limit farm activity. And so, for example, a community might have a minimum requirement on the acreage you need to farm. You know, you must have 40 acres, you must have 80 acres, something along those lines. And then in 2001, the Right to Farm Act was amended because local zoning, some places, they just took it too far. And so the Right to Farm Act was amended to include a zoning preemption. That means that local zoning does not apply and is preempted by the state. And since then, the courts have been really instrumental in further defining the boundaries of that preemption. And so it's important to remember that the Right to Farm Act provides an affirmative defense to these nuisance lawsuits that I mentioned, but it does not prevent lawsuits completely. It's not to say you can't still, a zoning still can't, you know, file suit against a farmer, a neighbor can't file suit, but the Right to Farm Act provides this affirmative defense that if a farmer is following these certain management practices, which we'll talk about, those are called the GAMPs, that they have this affirmative defense. And additionally, it provides this conditional preemption of certain parts of a local ordinance. And MDARD is the entity that they administer the Right to Farm Act, but a local community cannot send their ordinance to MDARD to have MDARD interpret it, to say this does or does not, follow the Right to Farm Act. What MDARD can do is tell you what the Right to Farm Act says. They can tell you what the farm market GAMPS, says, and they're actually getting more and more open to assisting to local communities that are calling with questions. Now the GAMPS, there's multiple different kinds of GAMPS. And again, the idea is that the farms have to be following these management practices to receive that affirmative defense from a nuisance suit. So manure management is one that a planner might run into in regards to the keeping of animals. Site selection and odor control deals with those large operations, CAFOs, or with some smaller operations as well. And then we're here really to focus on the farm market GAMPs, which were new in 2010. So within the right to farm, there's 3 key questions. You have to first establish jurisdiction. Second, determine if the activity is covered under the Right to Farm Act or a GAMP. And then there's this new classification, relatively new, where the GAMP says, if these certain conditions are in place, we're going to give it back to you, local community. And those only occur in a few instances. So let's walk through this. And if at any time you're confused, it's okay. So the first part, is this a farm or a farm operation? Is it producing a farm product? And is it engaged in commercial production? You'll find that a lot of seasoned zoning administrators, if a farmer comes in and wants to do X, Y, or Z, the zoning administrator starts asking a lot of questions. Do you sell this stuff? How often do you sell it? Well, I just give it to my brother. Well, does your brother pay you for those eggs? The zoning administrators are trying to figure out if you're engaged in commercial production or if this is really just a hobby. There's really no money changing hands. This is just a hobby. And so a lot of these questions, and these definitions become really important and really nuanced in terms of trying to understand that. So one thing I'm going to skip that, actually, that case. So is it a farm operation? What I want to point out here is it's the management of farm or a condition anytime as necessary on a farm in connection with commercial production. So is it necessary to commercial production? There was a case, this township of Williamston versus Sandalwood Ranch, where a stable had accessory apartments in the riding arena. And folks lived there. They didn't really have much to do with the horses. Every once in a while, they might feed them if the actual owners were gone. But the courts really took a hard look at this, and they said the renters they're not a necessity. They're not necessary to the farm operation under the Right to Farm Act. And so when we come into all of these, a lot of questions about, gosh, is it covered? Is it not covered? That's a good case maybe to refer to in terms of how the Court of Appeals reasoned their way through that particular issue. Is it a farm? Okay, pretty standard definition. It's the land, the plants, the building, etc. But they're used in commercial production of farm products. And in Michigan, a key published case is the Charter Township of Shelby versus Papish out of 2005. And the Miss Papish had some chickens, hens, was in egg production, and her farm activity occurred prior to these residences coming in around her, and she didn't have thousands of dollars egg production. She just had some receipts here and there. I don't remember what they totaled, but the court said that's enough. That is commercial production. And so the bar is low in Michigan, but it is up to the owner to substantiate that they are in commercial production by showing receipts, showing something as evidence of commercial activity. But the bar is low. I've heard some communities say you have to make over $2,500 a year. That's the court's. I mean, look. Just go ahead and read that case, the Charter Township of Shelby. The bar is low in Michigan. And farm product, I'm not going to read all of that. Obviously it's a lot of different things that constitutes a farm product. Okay, so second, what subjects are off limits for local regulation? So if it is covered in a GAMP, then it's off limits. So you cannot say we're only going to grow apples on this slope. No corn, no pigs. Nope, not going to do it. Zoning cannot regulate what kind of production, what kind of crops, the type of farm, and any other things that are covered by the GAMPs, like pesticide application or the care of animals. You have to put new shoes on your horse, whatever. No, that's not something zoning can do. So it is important at some point, depending on what's going on, that the zoning administrator, the planning commission, they do actually get in there and read the GAMP from time to time to figure out if the GAMP covers it and if there's a conflict with it. But if it's not in the Right to Farm Act or a GAMP, it is fair game for local regulation. In this Cena versus Lima Trust versus Ottawa County Road Commission, they wanted to put in a road in a cul-de-sac in the middle of a farm field, and the road commission said, no, you can't do it. I don't know what road ordinance they had, but they said, well, no, we're a farm, right? We can do anything, anytime, anywhere, any place. The AAA policy for the Right to Farm Act, which is not true. And so the court said, now hold on, you can't. The right to farm is not a shield. It's a shield from certain things, but it's not a sword for you to cut through all regulation, right? If it's not in the Right to Farm Act or the GAMP, it is fair game to regulate. Lima Township, and I'm sorry, I'm going through all these court cases because sometimes the court cases are the most instructive because they tell a story. So this Lima versus Basin has been going on for a long time. And this is the most recent case where Mr. Basin was basically had an excavating company, lots of equipment, steel, asphalt, all kinds of stuff. But he said, no, I have a tree farm. This is all for my tree farm. And really failed to substantiate any of that in court. And the court could not find that the storage and use of vehicles complied with any accepted agricultural practices. What he was doing was outside of the Right to Farm Act. So you can't do anything and be covered under the Right to Farm Act is what I'm trying to say. Now there's these delegate back, I talked about that as well. Category 4 sites in the site selection order control are relatively new. They were added in 2014 and have to do with kind of this new interest in urban agriculture. Chickens and hens right in downtown, wherever. And the Right to Farm Act came up with this new category 4 sites that said if you're in a primarily residential area, and they define it this way, it's not defined by zoning. Primarily residential means you have more than 13 non-farm residences within 1/8 of a mile of the site, or you have any non-farm residences within 250 feet of the livestock facility. And so the Right to Farm Act and the Keeping of Animals GAMP says if these conditions exist, Right to Farm is out. It's up to you, local community, to come up with regulations if you want to have, hens, chickens in your downtown and have eggs or whatever the case may be.
Can I ask this question on that? If it's in an agricultural zone area, Would that apply?
Yes. Yeah. There's a lot more at play there, but typically in ag areas, you don't run into this as much, but they do want the animal livestock to be.
I mean, I can see in the agriculture area to have 13, not like we have 12 adjoining parcels to our property. And I can see us having.
But are they within 1/8 mile of where you're keeping?
They're adjoining.
But the blue dot would be like where the goats are, let's say.
Okay.
And so it's likely that within 1/8 of a mile.
Within the blue dot. Wherever
from the blue dot.
Okay.
That you don't.
That would make sense.
Yeah.
Okay.
Yeah. So the larger parcel you have, you have a lot more protection. Yeah.
Okay. Thank you.
Yeah.
How does this come into play if the farm was there first and all this stuff shows up and all of a sudden, ding, Right to Farm Act is out and now it's up to the local zoning board?
Yeah, there are Right to Farm Act protections specifically when you were there first.
Okay.
And then the development comes up around you. I can't quote chapter and verse, but
Okay.
it is part of the protections of the Right to Farm Act.
You had in there pesticides. I sold a bunch of land because down by Spring Lake, they got some of these blueberry farms that are surrounding now, like condos and everything else. Well, they came up with a rule or ordinance that if the wind was over certain miles per hour, they couldn't spray their crops. In the spring of the year, that becomes quite a problem. They need to spray because the wind can go over. I can't remember what it is. I think it's like 12 miles per hour.
Yeah,
And they can't spray.
that's probably preempted by the Right
So
to Farm
they're
Act.
selling their blueberry patches and moving up by Rothbury.
Yeah, because pesticide use is covered in the GAM. So it's probably off limits. That's off limits for local zoning to have. So it's common too for ordinances to have, you can only have so many farm animals per acre. And typically that applies to hobby farms, not that commercial production. But whenever that is the case, you definitely want to consult with your municipal attorney because that's just a difficult area when you're mandating. Let's say you have to have 3 acres to keep your first animal and then so many acres above that. A lot of ordinances have those type of provisions, but some of it's government by bluff. So you want to work closely with an attorney to work through any kind of hobby farming regulation. So we're going to move on to the farm market GAMP. But before we do that, I wanted to quickly talk about the food processing. Under any law, whether we're talking about Right to Farm Act or there's Right to Farm Act, Farm Market GAMP, and then there's the Michigan Agricultural Processing Act. That act, which deals with all elements of food processing, very explicitly says local zoning applies, or zoning applies. It's very clear, okay? So whenever there's processing involved, zoning does have authority. This can get confusing as well because there's some processing, baking the pie, making the jam, they're just in their home. There's cottage food law, act as well, which still allows for local zoning, but still there's kind of a question mark there in terms of scale, where local zoning says, this is so small. There's no need to regulate this. And the other side of food processing, acres large food processing plants that are really industrial operations. And so that's an element where zoning does have authority, but we want you to know about this act. This is not an act that a lot of people just whip off the end of their tongue like the Right to Farm Act. But it's an important part of agribusiness and agritourism is that processing element. So as we move on to the GAMP for farm markets, which is kind of a focus for tonight. First of all, a farm market is different than a farmer's market. So that's a common misconception. We're not talking about regulating your Saturday morning farmer's market. This is something different. Farm markets can be seasonal, they can be year round, they can be in a temporary structure like in a tent, they could be in a permanent structure. So there's quite a bit of variation there. And as I mentioned earlier, it's normal to feel a little bit confused as we continue this conversation. So the Farm Market GAMP was edited pretty heavily in 2021. It is about a 2 or 3 page document. So I encourage all of you, if you're interested, to download the actual Farm Market GAMP and read it carefully. But it's very, very short. And so you have to really think about the nuance, and that's why Ryan's here tonight. So we know that the Right to Farm Act includes farm markets as a definition of farm operations, but the GAMPs for farm markets were developed to further provide a little more guidance on what constitutes farm market activities. Yes?
A farm market, is that what we mean by a roadside stand?
It can be a roadside stand. Yes. Yep. Yep. So one of the key triggers for a farm market is that 50%, and I don't want to read through all of this, but understand that the namesake ingredient, what that farmer grows, in this example, the blueberry, the blueberries need to be a key part, at least the majority, 50% or more of their gross floor area, of the products offered, of the average gross sales, have to be that namesake ingredient. So it's not to say that they can't sell other things, but that farm market needs a tie to the product that that farmer grows. There are farm markets out there where 10% maybe is grown by that farm market owner. They grow just the blueberries or strawberries and peaches. That's what they do. But they've got corn, they've got cucumber. They're selling 7 months out of the year. That's something different, right? That's not a farm market here that would be covered under the GAMPs. That's more like a grocery store or retail operation. Okay? That can be a little confusing too. And this is new also in terms of where farm markets can be located. There's a term called affiliated properties in the farm market GAMPs. So that, for the example here, is the farmer owns that blue square on the lower 160 acres, and then they bought a property in the A section, maybe a 5 acre up on the main road or near that intersection. They bought some commercial property because it's better, they can sell more product there. And so as long as those properties are owned by that producer, they can have a farm market at a different location. It doesn't have to be where they're producing the product. And if it's a greater than 120 square feet, it must be at least 165 feet from all non-farm residences. And then finally, there's no mention of any kind of specific zones or where agriculture occurs anymore. That's changed. So it's, it cannot be in a platted lot, in a subdivision or a condominium, unless they authorize that of some kind. So trying to keep farm markets generally out of a platted subdivision or a very clearly residential setting. So that is somewhat new as well. And there's several key elements of what's off limits because it's covered in the GAMPs. In terms of site plan and requirements. So setbacks, whatever the local setbacks are, can be applied. Building permits, if you build a building, building permits are required. Likewise, electrical, mechanical, plumbing, should the building need those things. The driveway does need proper permitting through the road commission or MDOT. The ingress egress is subject to permit. And then finally, the parking spaces, the local community can determine how many parking spaces are required for the use, but they cannot mandate the surface. So they cannot say asphalt. They can't require asphalt, for example. They have to accept other kinds of surfacing. They can't dictate that. And that's kind of the long and short of it. Oh, one more sign. Farm markets are allowed to have a sign. The sign has to meet the local zoning standards for height and that sort of thing, but they are allowed to have a sign. And these things kind of come from some communities where the zoning went too far, right? The zoning required a engineered site plan for a temporary pumpkin stand or something like that. And so that's the farm market GAMP is kind of like a, hey, let's try to be reasonable here in terms of what the use is and what you're requiring. Now that said, if a community might have standards that are in and above those things, let's say landscaping standards, something to that effect. If it's not in the GAMP, if it's not these things, right, the idea is that the local government can regulate it. However, take that with a grain of salt. The goal is to try to be reasonable, to not require maybe a full engineered site plan for a simple shed or something like that they're wanting to use to sell their product. The site plans must be created. So on the other hand, farmers who say, I'm a farmer, I don't have to do a site plan, right? The farm market GAMP clearly says there will be a written site plan for potential MDAR review to look at how local government could be regulated. So local government can regulate if they have regulations in and above those things, but just try to be reasonable. So this is one of the pivotal things of the farm market GAMP is this notion of marketing, that these farm markets or farmers can engage in these certain activities as a way to market their products. For example, farm tours, demonstrations, cookings, and other classes. The key point is that it has to be incidental. The farm market is incidental to farm products. It has to be related to, with the intention of selling more farm products. So some of the things like a wedding barn, for example, is not incidental to the farm product. It's not incidental to the blueberry, right? It's all about the blueberry. So this is one of the more nuanced points in the language of the 2021 farm market GAMP is that word incidental. How is the farm product incidental to that farm market or the educational activity and promoting the farm market? And finally, there's some questions about, sometimes we get questions, is it agribusiness? Is it agritourism? Is that farm market? And so I just want to kind of run through these definitions. They could be. So agribusiness typically is a value-added activity, and that typically involves processing of some kind. And so they have a raw product, they're processing oftentimes, and then there could be marketing, entrepreneurship. So these are our cherry jams, our salsa makers. A lot of that is an agribusiness. It's a really broad spectrum. Agritourism is when you invite the public to come in to your property, to the farm. And ideally, there's no change to rural character. There's no interruption of the farm product or farm activity when this agritourism occurs. There's a lot of activities that are outside of the farm markets that are maybe more like agritourism. That might be, the wedding barn, that kind of thing, where you're inviting people to a part of your farm, but it's not covered under the Right to Farm Act. It's not incidental to the blueberry. That is subject to local regulation. So just a few kind of blurry scenarios. I'm sure you've seen them, but or heard of something like it. But a gardener starts with kale and herbs. They build this really handsome building. They just needed a basic zoning permit because it was purely an agricultural building. They didn't get a building permit. And then 2 years later, he rents the building for weddings and small gatherings. And that's great, right? It's farmer, it needs the extra income. It's very difficult to be a farmer. The goal here is that your community is ready, right? It's not a hard no. Your community's thought through it. Do we want to allow wedding barns? Where do we want to allow them? And you're ready to respond. Or likewise, you're ready to counsel that the farmer that's building the very handsome building to handle the kale and the herbs, to let them know what's down the road. Here's another scenario. This is more of an agribusiness, but farmer with 5 acres, they're growing hops. And again, permitted through zoning, agricultural buildings, so no permits, very simple building permits. And then the township learns on Facebook, they're taking in hops from several other growers now. They're processing them. They have more employees. It's a great issue, right? It's a great problem, but it changes because there was a Right to Farm Act preemption, and now it's a processing facility and more of an agribusiness facility. And so this is a bit of a head spinner for government, but it's becoming more and more common.
So what happens in that case?
Well, hopefully the community is ready for it, right? They've thought through it. They have agribusiness on the books, and maybe then he just has to go, or she has to go through a permitting process at that point.
To continue the.
To continue. There have been cases where they've been shut down. I think down in Marshall that happened until the community had the regulation on the books.
Do you have to claim your business as an agribusiness, like strictly to run it as an agri? So a scenario is that, let's say you have a small farm that's not, your standard apple or not oranges, but apples or whatever orchard. Say something as I don't know what I can think of, it's a lavender, Do you have to claim it as an agribusiness because it could be like agritourism too for your place? Or is there a hard line of claiming my business as an agribusiness, or does it evolve through the years and then it just becomes an agribusiness? I guess is what I'm asking.
That's a great question. So maybe I'll have Ryan. Ryan, can you hear?
I heard part of it. I heard something about lavender and claiming as agribusiness. Could you rephrase it, please?
Yeah, so I'll rephrase it. So what if you start off, and help me if I'm wrong, but
Yes.
you start off growing lavender, and that's where you start. And you then evolve maybe just a little bit. You're trying some things, here and there. Did you have to claim that you're an agribusiness up front to start growing the lavender? Is that right?
Yeah, or start doing things such as, I don't know if it's even permitted, having a store inside your land, for example, because you
Right.
can have,
So-
you have a land with lavender and just sell, in a stand or something, your little lavender bundles versus say, throughout the years, you've evolved, and then now you're putting a little store that people can come in. Is that even
Right.
permitted? Or
Okay,
can you start
so-
claiming that?
Take it to the next level and be making soaps or sachets
Correct.
and turning it into something that's
Correct.
remarkable.
So I'll try to answer that. And I think, so Ryan, the question is, it's definitely You start off with lavender, you start small, and then you grow, but incrementally. So it's a really good idea before you start to engage in whatever commercial you're thinking about investing in, to have that conversation with the zoning administrator. This is what I'm thinking about doing for now. Maybe in 5 years, here's my dream. I do want to have a 200 to 300 square foot little store, and talk through that, because there might be some phasing where this is so small it doesn't require a permit, but when you get here, you do need a permit, and so understanding where those divisions are is important.
Can you claim that you're still, I don't know, a farm market or a non-agribusiness if you begin to have an actual store that people are coming into? Is that even?
Yes.
Okay.
Ryan,
Mary?
did you hear that?
Yeah,
Yeah.
it's gonna, the key of what she's asking is gonna hinge on how we define the growth. If the growth is still around that namesake product or the products that she's growing on site, then she should be able to maintain that protection with right to farm. If she starts expanding, and not only am I selling lavender soap and lavender for whatever, but I'm also selling widgets and gadgets, and those widgets and gadgets are 70% of my sales, then she would lose that protection.
So in terms of product definition though, would you define, so let's say, I don't know, like soaps and lip balms are directly with lavender, can be said that they are products. But say you start venturing out to say, purchasing dolls online that you can sew in lavender inside for infusion or whatever, because I've seen those. Is that technically still called your product? What is the definition of product in that case? Because it does have lavender, so if you have a stuffed toy, little bear, and then you sew into the
Yeah.
bear a little pouch of lavender, is that still considered a product? Does it encompass the definition of product?
I would argue that there's probably standing on that in court with other products, and going back to Mary's example of the blueberry pie. I mean, obviously, when you bake blueberry pie or you make blueberry jam, sugar is not coming from your farm. I mean, nowadays we do sugar beets in some parts of Michigan, but traditionally sugar comes from off-site. Your flour might come out from off-site, but the namesake product is in there. And I think you'd have probably reasonable grounds to argue that the lavender infusion is the namesake part of that product, and that you probably would have justification to make that argument. That said, it would still be something that potentially could be subject to challenge. And it goes back to Mary's argument of have the conversation with the zoning administrator. If they're okay with it, you're probably good. If not, you may need to consult your attorney to be certain that your attorney would feel comfortable making that argument in court. I always hate to tell people 100% you're going to win or you're going to lose, because basically from our standpoint, you're going to become the case study for all of us to learn from. But I think in this case, you'd probably have fairly reasonable grounds. I don't see putting lavender into a teddy bear and selling it is much different than putting it into a soap. I mean, the wax you're putting into the soap isn't coming from on site. It's just a different material, but same concept legally.
All right. Yes.
I would look at that a little differently. I'm not an expert on this, but if the cost to you of producing the lavender that's involved in the teddy bear is, let's say, 50 cents, and the teddy bear you're buying for $4.50, and then you're selling the teddy bear with the lavender for $20, I don't think that that's under right to farm. I think that the economics of that are something else.
Mm-hmm.
That's just my opinion.
I think the argument against that would be on this slide. It's the or part. Is the product coming from it? Like is the namesake product in it or not? We don't have any case law that I'm aware of, and Mary, correct me if I'm wrong, that's ever specifically defined how much of the final product has to be the namesake. It just has to be in that product is the case law we have.
Interesting. Thank you.
Yeah.
Yes.
What I'm concerned with is I'm a fourth generation farmer, own hundreds of acres, and I keep hearing that I gotta go to the zoning administrator and ask what I can do on my we have a lot of money invested in this operation. Where did they all of a sudden become my partner?
Well,
I don't understand that.
I think the way to think about it is, the state adopted this Right to Farm Act and they preempted zoning. But we're heading into this realm where it's not just agricultural commodity farming anymore. It's wineries, it's wedding barns, it's these farm markets and namesake ingredients and local, tourism, right? People want these authentic experiences. And so farms are sounding different. They're attracting people to them versus it used to be just low density. Let's keep people out of the agricultural district, right? And now we're attracting people to it. And so it creates some conflict. And so my biggest suggestion would be you contact the zoning administrator because you want to be smart with your investment. Whatever you're investing in terms of buildings, sales, entrepreneurship, you just don't want to run into hiccups. So
we're going into a zoning administrator that doesn't know anything about planning, doesn't have a college degree in horticulture or anything like that, such as majority of my counterparts, all well-educated, know everything. And we got to go to hear that someone that doesn't have 5 cents invested? It doesn't make sense.
Is there a way to escalate? If you have concerns like that, is there a way to escalate it beyond your local zoning board? Like who can?
Well, you can, anyone has the right to appeal the decision of a planning commission or a zoning administrator. And you can take that, to a local zoning board of appeals, and then it can go on from there. The Right to Farm Act was developed such that if the farmer prevails, the judge can award or require the person who sued the farmer to pay their legal costs. So it sort of invites the local community to be very well educated and prepared if they're going to try to win a Right to Farm Act, lawsuit. Do you want to add anything to add? Yeah, please add.
Yeah, I would add, there is one other component to her question as well. In terms of elevation, Mary's correct. There's local ways to do this all the way to court. But you also have the ability, the township does, or the farmer has the ability to request a conformance review by MDARD as well to determine whether you are in conformance with GAMPs, because ultimately this conflict's occurring because the farmer's saying, I have right to farm protection. The township saying, no, you don't. Our zoning applies. You can request that conformance review prior to going to court potentially. If they come out and determine that you're in conformance, the township would be in a very difficult position to move forward. If the state determines that you are not in conformance, as a farmer, you have 2 options. One is you look at the review and come into conformance to obtain that protection, or you risk going to court over the zoning component, in which the township doesn't care about right to farm. They've got the determination that you're not conformance. They're going to treat it as a zoning violation. So you do have that one additional step here with the Right to Farm Act in MDARD that you would not have in normal zoning situations.
Yes.
I want to add to Mr. Edmondson's question here a bit. Farmers make decisions in ad hoc, extemporaneous kind of ways many times, and they have to, let's say, in regard to frost protection. And I'm particularly thinking about controlled atmosphere agriculture, where you have structures. If I have to wait over a weekend or a night even to go into my zoning administrator and ask for a permit for a structure, am I gonna do that as a farmer? And is that fair to me
Right.
to ask me to do that if by Monday morning when they come in, my crop is gone?
Right.
I'm particularly thinking of my case, my daughter who raises cut flowers. We may hear a weather report at a certain time that says, well, we look like we're gonna project frost for Saturday night. It's Friday, our zoning administrator isn't even in on Friday. What am I gonna do?
Mhm.
And you have things like caterpillar tunnels, low tunnels, high tunnels, hoop houses, non-retail greenhouses that all don't fit into any kind of categorization that you have in their GAMPs at this particular point. And am I covered?
Yeah,
I don't want to be able to, I go to my zoning administrator right now and they say, oh, just come in and ask.
Yeah.
Are you kidding me?
Mhm.
That's what I told him. I said, are you kidding me? Really?
Yeah.
That's what you want me to do?
So,
Are you kidding me?
so, yeah, I sympathize with you. I think in most cases, and I can't speak for every community, but in most cases, agricultural buildings are a simple approval. All they're looking for is setbacks, but not any more than that.
But you
Typically, no,
understand-
I do understand what you
In
mean.
regard to timing, timing is
Yeah.
everything in farming.
Mary, in his case,
Yeah.
in his case, if you're talking about bringing in temporary equipment to deal with, sir, are you talking about like blowers, heaters, things like that? You're talking about something temporary or something very quickly, correct?
It could be, but it also involves structures.
Understood.
The hoop house.
A hoop house, a high tunnel, a low tunnel, a caterpillar tunnel, there are various scales of structures that are not covered by any kind of GAM,
Yeah,
and they're not covered by anything. Do I need to go in and ask the zoning administrator if I'm gonna put up a low tunnel or let's say a high tunnel
I mean,
during, the next day or two, and they aren't even in their office?
like I said, I can't speak to, we can't speak for every zoning ordinance out
No, I
there.
understand that.
But where I was, there would absolutely be no permit for a temporary hoop house type of structure over plants to protect from frost, that you might just,
Mary,
that you might remove.
I just was fine for.
Mary,
Yeah,
I
and it
think,
depends on the size.
I think in this situation, if this was a permanent structure going in, it's not even a question, you need to get the permit. If it's a
Right.
temporary process, as he's suggesting for something like frost, I think you would be protected by right to farm if that's considered, and I don't know the industry, again, I'm not a horticulturist, but if that's a normal practice to prevent frost to save the crop, and you're going to put it up for a couple days because there's 3-4 days of frost coming in and you're taking it down, I think a township would be very hard pressed to come after you on that. Now, if you leave that up for the next 2 years and claim it's temporary, they're going to be able to say it's a permanent structure and come after you. But if it's a normal part of the normal ag process that's utilized to protect the crop, I think you'd probably be able to get away with that without a problem, without going to them at all.
Well, a lot of this is determined at the discretion of the administrator. And I feel really uncomfortable about that because, as Mr. Edmondson has said, that is something that I have not asked the zoning administrator to be a part of my business as a partner.
Mhm.
So permanence or temporariness somehow needs to be defined, because I find in my township that there are structures to protect vineyards, frost structures that have been up for what, Dave, maybe 15, 20 years?
Yes.
Mm.
And they're considered temporary.
Mhm.
And my structure that I put up is considered permanent. There's no concrete foundation. I hate to be too specific about this because I understand that your education here is more general.
Can I add one thing to that, Mary?
Yeah, go ahead.
So I think the question he's bringing out, there's another spin on this as well. And I know at least one person in the room is dealing with this is, historically, when we've dealt with GAMPs and we've dealt with structures, it's always been on the understanding of, look, if you're going to build a permanent structure, you get the permit, you do it. If you're going to put up something like a table or a tent, it's temporary, it's a non-issue, it's protected under right to farm. But we are running into a few townships, and it's a very few, that are requiring tents receive a special use permit, and they're charging exorbitant fees to do that. And I think it gets into very dangerous legal ground for a township to do that under right to farm, because they have to justify that cost, that fee. And if I'm advising a farmer on that, one of the options that a farmer can do to get around that loophole, instead of paying $200, $300, $400 per tent each year for 10 years, if the township is going to play that game, what a farmer can do is, you know what? I have every right to put up a structure. I just need a basic zoning permit, which you cannot deny me one time because I have that protection under right to farm. I'm just going to put up a permanent structure instead of a tent. And now you have to live with a permanent structure there instead of working with me and being reasonable on an annual tent. And so there are ways as farmers you can fight back. You need to ask the right questions. You need someone to kind of walk you through that. And unfortunately, if you have an obstinate township, you may need to get an attorney involved. And that's very unfortunate. We hate to see that. But there are ways you can fight back in those situations, potentially as farmers.
There you got a question in there.
Oh, yeah.
Oh, backing up a little bit. A farm market, at least 50% of the products must be grown there, okay? At least 50% of the average gross sales. Is that the gross sales of the farm market or of the farm?
I believe it's of the farm market.
Okay, that's important because the farm, hopefully we sell, make more money than the roadside stand makes.
Yeah.
Maybe
So-
not.
So Mary, just to clarify, I mean, there are some farm stands who are they're aggregators. So basically, they don't grow anything, right? But they like get a bunch of farmers together and because they're in a prominent location, and they sell those goods, and then they take 30% and the rest goes to the farm. So does this say that that's no longer allowed? That's illegal?
No, it's just saying that if, my example of, there's a farmer that owns a farm market, but they only contribute maybe 10%. They only have one or two crops, and then they invite a lot of, 90% is other farmers.
Right.
So that's not covered under the farm market GAMPs. That would be treated like a retail or grocery store or just a business defined in the ordinance a different way.
All right, that helps.
Mhm.
How do we get people to write a GAMP where a GAMP doesn't exist?
Brian, you want to take that? Can you hear it?
Can you be more specific? Are you talking about amending an existing GAMP to add additional language, or a totally new GAMP?
A totally new GAMP, because it seems to me that farm structures is an area where there is no guidance at this particular point under the GAMP or the right to farm. It's not specific enough.
So you are 100% correct. This was a very contentious point a couple of years ago when we did these major revisions to farm market GAMPs, because we had kind of a segment that was lobbying very strong on the agribusiness side to include farm, like barns for wedding venues, things like that, under right to farm. Now, that said, if a barn is going to have an animal in it, under the care of animals, basically barns are already protected. So it is in there. It's in a different GAMP. Within the farm market GAMP, we cannot include that, because to go into that direction, we risk opening up the entire right to farm law and possibly having it gutted or eliminated. And the reason being is, the structure of this legally is you got the right to farm law that references GAMPs, and the GAMPs are put together by the committee. They're basically guidelines, management practices. We cannot exceed or artificially expand the intent of the right to farm law when we write these things. And so, for example, with the wedding venue, if we would have done that, we would have artificially extended it. And this is why we get into this problem that Mary kind of gently alluded to a little while ago. So you can grow the blueberry, you can sell the blueberry jam or the blueberry pie, but you can't process that blueberry on site. And it has to do with the way the right to farm law is written about basically taking a product you grow and selling it, nothing about processing. And so I can't say it's completely impossible to do what you're talking about, but we would have to be very, very specific as to how we worded that and what the intent was, because the Ag Commission is very sensitive to this issue because of the various factors that go into right to farm and some of the controversy on it. And that said, to be quite honest, we're very fortunate to even have a farm market GAMP to begin with. It was added in 2010, as Mary said. There are some that will argue legally that really there shouldn't even be a farm market GAMP, that we're kind of extending artificially the right to farm law even by having it. It puts us in a very precarious position in terms of what we define in it and how careful we have to be with the language we utilize. But if you had specific examples of what you're thinking, I would be happy to hear them.
All right, it is 8:10. So Ryan, maybe you can stay another 10 minutes or so.
Sure.
If you want to depart, it's perfectly fine. We understand. So I just want to give anyone a free out that wants to go, because I know we're way over time. Yes.
Real quick, I know that the answer to this is beyond what we're talking about, but I kind of want to hear it, which is the relationship between GAMP and all these food safety laws.
Do you want me, Mary, do you want me to answer that?
Go ahead and take that.
So this was a big part of this year's review and conversations about this. And the reality is and MDARD will admit this, the two divisions within MDARD, the food safety side and the GAMP side, the food safety people didn't even know what right to farm was. The right to farm people didn't even know the food safety laws applied. In a nutshell, what you need to understand as a farmer is just because you have right to farm protection doesn't necessarily mean you don't have to follow food safety laws. So if you're selling a squash whole, you're fine. If you're selling frozen meat, you're going to be elevated under that food safety law that you still have to follow their rules. So again, you're selling the squash, you need a table and a tent. That's all you need. You're fine. If you want to sell frozen meat, you fall under food safety laws. The way those laws are written, you're basically being regulated like a grocery store. You need to have restrooms in your facility now. Okay. And that sounds crazy, a tent and a table, but what that does for you as a farmer is it means you need to think about your business plan. Do we want to up our game and take it to that next level and invest? Or is it not worth it? And do we need to withdraw certain products so that we still fall within the GAMP separately and not fall under the food safety law? So you have to be cognizant of the food safety laws when you're selling products. And if it's anything beyond basically we're picking it off the field and selling it, you're going to want to check, because the food safety law is very nuanced. Selling a certain type of jam, let's say blueberry jam, is probably fine. But selling tomato jam, which I never even knew existed until last year, tomatoes are classified differently. So tomato jam is going to fall under the food safety law, whereas blueberry jam isn't. So now we're back to that slide with Mary with all the headaches, right? Okay, these are the nuances of these laws that you have to be aware of. And if you're not sure, you can pick up the phone, give me a call MDARD, call Farm Bureau. We all have experts that can walk you through some of this.
And keep the dog in the house.
I would add to that, MSU has a host of food innovation counselors who are very knowledgeable about all of these different laws that help people to usher a product right onto the market. So MSU Extension is a great resource also for those innovation counselors. Yeah.
So to add to a complicated question, if, as it appears, in Leelanau County, we're going to start seeing many more of these conflicts as land is being sold, developments are being proposed. how can local rural communities be prepared for the agribusiness, which is being touted by many people as, well, that's the way we're gonna stay with the character of Leelanau County, is we wanna promote agribusiness. Well, one farm is not another farm. And I don't know how the public is gonna be able to tell the difference in many cases. But that being said, you know, back to the planning and zoning part of this, what can local communities do or get started doing? I believe our community is doing a lot already, but, you know, we need to educate a lot of people about this and also be prepared, like you said. Hopefully we're prepared instead of being reactive to some of these zoning proposals. That's a big question. I understand that. Can you do it in 5 minutes or less?
Well, I think, again, you want to kind of start off with engaging the community to the extent that you can around conversation. A lot of times people don't show up to planning meetings or planning hearings. And so it's not until this is going to be right next door that people start talking. I totally get that. So planning is not always the be all end all. But I think kind of drilling down on scale is important to agritourism and agribusiness. So we talked about the scale, it's so small, it's not worth regulating. From a zoning perspective anyway, it's inside the home, they're making jam seasonally and selling it. You know, it's just not maybe big enough. Then there's, well, now I need a 30 by 50 pole barn, you know, to do what I'm doing. And maybe that's another scale. Maybe that's a site plan review scale. I know I'm getting in the weeds, but I think you can appreciate what I'm trying to say. And maybe we need a sign and now I have employees. So we need a site plan review, you know. And then there's another level that hopefully you know in advance and you can tell the farmer. And so, because one of the tricky things with this piece is that once, you know, the farmer owns the land, they own the building, right? There's a tendency to want to stay on that property, right? Because there's so much investment there. So to jump to another scale to say, no, well, now you have to be off-site in an industrial zone or in a commercial, you know, something like that. That's a big leap, right? And so really thinking about that, or about the special land use sector, you know, maybe they could go a little bit bigger on their own property, but how big is too big, right? There is a point where some of these ag processing facilities, they no longer fit. They're not on a Class A road, for example. The infrastructure isn't there. So drilling down on those kind of intricate points for at least agribusiness. For agritourism, it's kind of it's a little bit of a different animal. I think amplified music seems to be probably a pinch point in a lot of communities in terms of events, and sound seems to be a sensitive point. So thinking through that.
Exactly.
But I don't think seasonal traffic, let's say for U-pick operations, for a corn maze, for those kinds of things don't tend to ruffle a lot of feathers, you know, for a true agritourism experience. Even a bona fide farm to table dinner, that's covered under farm market camps. Those are not big head turners. But I still think the community needs to plan for any variety of these potential agritourism experiences as well, and classify them. So, and I have a number of ordinances and things I can help you with too from around the state. Yes.
Is there anybody in the state that's had this that you've seen where they've really put this into their ordinances to support the local agriculture businesses?
Yeah, there are. There's a number of townships that have been fairly proactive, writing very clear ordinances about what they want to allow and where. Other communities in terms of the agribusiness piece that have kind of defined different scales of operations. So yeah, I would say so. Ryan, can you recommend any particular ordinances or
It's actually funny you say that. I'm actually working with an attorney in a township right now on an agribusiness. I think the key, what I would actually argue, Mary, everything you've said is dead on. I think using the special use process, I argue and I teach that that's a best practice because the agriculture industry, it as a farmer, not us as necessarily planning commission members or township officials. And it's an evolving industry as well that's seen a lot of change in the last 20, 30 years, especially in Northwest Michigan. What I would argue is approach it with a similar mindset to like you do home-based industry or cottage industry. If you've been around planning and zoning for 20, 30 years, it used to be you have a litany. You can do this, you can do that, you can do tax preparation out of your spare room, but my wife wants to cut hair. Well, that's okay, but we need to amend the ordinance. Give us 6 months and we'll do it. The way we teach cottage industry and home-based businesses, we look at the impact, like Mary was saying, the scale and the impact. We don't really care. We don't get down into the weeds of, well, are you making wine versus beer on your site? We're more concerned about what that impact is and is it appropriate or is it not? And what are those ordinances that affect that? So once they're in place, someone down the road wants to do wine today, someone else wants to make blueberry jam or whatever it is. We don't really care. We don't have to amend the ordinance each time. We've got something in place that's appropriate for the scale of wherever that piece of land happens to be. And I teach that as a best practice, and I encourage utilizing language like that.
All right. Well, folks, the hour is late. We could go on, I'm sure. But Ryan Coffey, his email is here, and my information is here. Feel free to reach out to us with any other questions that we didn't get to tonight, or, hey, I'm confused about this, I'm thinking about this, I'm wondering this. We are here to help you, and we can also refer you to other experts as well. So thank you so much.
Thank you.
Is that right?
Is Ryan's Coffee the individual